Welcome to the Bankruptcy Clerk's Office for the Northern District of West Virginia. As bankruptcy clerks, they often hear misconceptions, half-truths, and outright myths regarding the bankruptcy process for individuals. Also, many attorneys in this district have assisted us with this video in the hopes that having dispelled many of the misconceptions here, they can conduct more informative and efficient interviews with their potential clients.
This video contains 10 common myths, misconceptions, and half-truths about filing bankruptcy.
The first myth is, I can choose what debts and assets to include in my bankruptcy case. The second, once I file bankruptcy, I can keep my house and my car without paying the note. The third, all my debts are discharged in bankruptcy. The fourth, I should transfer my assets before I file bankruptcy. The fifth, I should pay my friends and relatives before I file bankruptcy. The sixth, if I forget to list a creditor, the debt is not discharged in bankruptcy. The seventh, filing bankruptcy will ruin my credit score and I won't be able to obtain credit after bankruptcy. The eighth, mortgage and debt consolidation options are better than bankruptcy. The ninth, everyone will know I filed for bankruptcy, I will lose my job, and I am a bad person. And the last myth is, I can't afford to hire an attorney to file a bankruptcy case. By the end of this video, we hope that you will be more informed about the bankruptcy process, what it means when a person files a bankruptcy petition, and some of the consequences associated with that choice.
The first myth is the one we hear the most often. Commonly, we hear this as a file on bankruptcy statement. For example, someone might say, I filed bankruptcy on my credit card and not my house. The intent behind this statement is that the individual believes that it's his or her choice regarding which assets or liabilities to include in their bankruptcy case. Roger Isla explains why individuals don't get to choose to include their credit card debt, but not their house debt, in a bankruptcy case.
In a Chapter 7 bankruptcy, when you file the petition, it creates an estate, much like when somebody passes away, and all of the claims against the estates are the debts, and you really don't have any choice in the matter. You have to list your house, your car, your ATV, your credit cards, anybody that you owe any money to at any point in time has to be listed.
Our second myth can be a dangerous one. Commonly, we hear this from an individual who believes that he or she can keep a house or a car without regard to a debt secured by that house or car. The individual thinks that when the debt is discharged in bankruptcy, the creditor can no longer foreclose on a home or repossess a car, because the individual is no longer personally liable on the underlying note. Todd Johnson explains the difference between a discharge of personal liability on a debt and a secured creditor's right to liquidate its collateral.
Most debts in bankruptcy are dischargeable. That doesn't mean that the debt goes away and isn't owed. It just means that the creditor can't collect it from the debtor. And that works well with credit cards and medical bills. But home loans and car loans, those are also a dischargeable debt. But if the debtor wants to keep the home or the car, they do need to keep paying, while their obligation to pay can be discharged so that it can't be collected. The lien against the home, the lien against the car survives bankruptcy. So if they do want to keep their home or their car, they need to continue voluntarily making payments on that debt in order to keep that asset.
Because bankruptcy is federal law, it is a legitimate, tested, and authoritative method for discharging debt. Although Article 1, Section 8 of the United States Constitution authorizes Congress to enact uniform laws on the subject of bankruptcy, there is no constitutional right to a discharge of indebtedness. When it enacts laws on bankruptcy, Congress can forbid the discharge of certain types of debts. The rules governing the non-dischargeability of a debt can be complicated, and rules can vary depending on what chapter of the bankruptcy code an individual chooses to file under. Kelly Coder generally explains the types of debt that are common to individuals and which are generally not discharged in an individual bankruptcy filing.
In individual bankruptcy filing, student loans generally are not dischargeable. They can be, but it's a very difficult process. It's actually something I've not attempted because the guidelines are so strict. So I generally tell clients, student loans are not dischargeable. There are certain taxes that are not dischargeable. Most taxes are not, but in certain instances they can be. But that's a very detailed process to figure out which kind of taxes are dischargeable. And then also domestic support obligations, child support, spousal support, those are not dischargeable as well.
Our fourth myth is unfortunately very common. Generally, this occurs when an individual has some land or property that he or she does not want to lose to creditors. David Bissett, a trial attorney with the United States Trustee Program, explains what happens when an individual attempts a hidden asset scheme.
A scheme to hide assets from a bankruptcy trustee and creditors involves both bankruptcy law and non-bankruptcy law. In a Chapter 7 bankruptcy, if the court determines that the transfer took place in the year before filing and was made with the intent to defraud a creditor, the debtor may lose the right to a Chapter 7 bankruptcy discharge of all debt. The individual would have gone through the bankruptcy process and received no benefit. Criminally, the individual could be imprisoned up to 5 years. One of the duties of the U.S. Trustee Program is to report any kind of criminal activity to the U.S. Attorney's Office for criminal prosecution.
Martin Sheehan will now explain how he recovers fraudulent transfers and what happens with an asset that is never disclosed to the case trustee in Chapter 13.
Under the Bankruptcy Code, the bankruptcy trustee can avoid or more colloquially claw back assets that have been transferred prior to the filing of a bankruptcy case in a way that we describe it as a fraudulent transfer. Fraudulent transfers include both objective basis, if you make a transfer to someone you know and love, although you don't necessarily have the intent to defraud, the objective facts can support a finding of a fraudulent transfer. You can also have a fraudulent transfer where you have the actual intent to defraud someone. The standards are similar but slightly different. Under the Bankruptcy Code, you can reach back to a transfer that occurred 2 years prior to the filing of the bankruptcy petition. And because a bankruptcy trustee also can stand in the shoes of creditors, he can also make use of state law, typically the Uniform Fraudulent Conveyancing Act, to recover property. The statute of limitations is widely perceived to be different in the state court system, the state statute, than it is at the Bankruptcy Code. There's both a 1 year and a 4 year component to that. At the outside, you can go back 4 years. All of a debtor's property becomes property of the estate. That's the technical term. If you forget assets and fail to list them, that can become a problem for you later on. Unlisted assets become property of the bankruptcy estate, and they remain in the estate even though they're not administered and even though nobody is aware of them. We typically see this with lawsuits that were not reported at the time of the filing of petition. Those cases end up needing to be reopened, the money needs to be administered, a trustee needs to be appointed again. So there is an advantage to making the disclosures early, making them complete. If the trustee doesn't administer an asset at the time and abandons it, or the case closes and then it's automatically abandoned, then you can go forward in a free way. But if you've forgotten it, haven't listed it, potentially it can come back.
Our next myth is a variation on the scheme to hide assets by a transfer of title. Here, an individual commonly says that they want to pay off debts owed to friends and relatives before filing. That way, it won't be included in the bankruptcy schedules as a creditor, and the individual can avoid a perceived social stigma. Jay Byram explains what happens when the certain creditors receive preferential treatment before an individual files bankruptcy.
Well, the purpose of bankruptcy is to give a debtor a fresh start, and at the same time to see that similar creditors are treated equally. If you want to pay your buddy off before you file, it may be a problem, because if you pay your buddy more than a certain sum of money in the 90 days before filing, then the trustee can go to your buddy and demand that money comes back to the bankruptcy estate. Now, if you decide to pay any relative any money within 1 year before the filing of a bankruptcy, the trustee can go to that relative and say, I want that money back for the bankruptcy estate. And I have seen that happen. Finally, you can pay all your secured creditors in these time periods because they have liens and they're treated differently from an unsecured creditor like your buddy would be, or your Uncle Charlie. And finally, you can pay these people after you have filed. The law says specifically that nothing prohibits you from paying a creditor that's been discharged in bankruptcy. And so after you file, you won't have a bunch of bills where there might be enough money left over to pay your buddy.
Myth 6 is half true. We usually hear it after a bankruptcy discharge is entered and the case is closed. Generally, a creditor is seeking payment of a debt from the individual that arose before the bankruptcy petition. The creditor states that because it was omitted from the bankruptcy case's mailing list, it never received notice of the individual's bankruptcy filing, and therefore the debt owed was not discharged. This comes to the clerk's office when the individual attempts to reopen their closed case to remedy the omission by amending the bankruptcy schedule to include the creditors and simultaneously stop the debt collection effort. Ryan Johnson, clerk of the Bankruptcy Court for the Northern District of West Virginia, explains when omitted creditors might hold discharged debts and when they might hold debts that are still valid and enforceable.
In a Chapter 13 case, a creditor must be affirmatively treated in the plan to be paid. This means that a creditor must be notified that a bankruptcy petition was filed or have independent knowledge of the bankruptcy petition in time to file a proof of claim. A creditor who is omitted in Chapter 13, who does not have notice of the bankruptcy filing, and who is not treated in the Chapter 13 plan will generally hold a debt that has not been discharged. Now in Chapter 7, the answer is slightly different. Over 90% of the cases in this district that are filed under Chapter 7 don't have assets to administer. So this is what happens. A Chapter 7 petition is filed. The clerk's office will send a notice to all the creditors listed in the debtor's petition that the debtor has filed for bankruptcy. The notice also instructs creditors not to file a proof of claim unless specifically directed by the clerk's office. After the 341 meeting, the meeting of creditors where the trustee examines the debtor, the trustee will determine whether or not assets exist to administer in the estate to pay to creditors. If assets do exist to administer, the trustee will tell the bankruptcy clerk's office this fact, and the clerk's office will affirmatively send a notice to all the creditors on the mailing list to file a proof of claim. For the vast majority of cases in this district, however, there are no claims to administer. This means creditors are never affirmatively notified of a claim's bar date. In these cases, no asset Chapter 7s, where no claims bar date has been set, debts that are not listed in the original petition are nonetheless discharged. In the event the bankruptcy case is reopened because the trustee has discovered assets, then those creditors that were omitted in the beginning must be affirmatively notified to file claims. And if they are not affirmatively notified in these reopened cases, which are very few, then they may hold a debt that is not discharged. However, as a general rule, in a no asset Chapter 7 case with no proof of claim bar date, a creditor that is omitted from the original schedules of the petition nonetheless has a claim that is discharged in bankruptcy.
Myth 7 is also a half-truth. For a person with a good credit score, a bankruptcy filing will have a negative impact. Many individuals that contemplate bankruptcy, however, do not have a good credit score to start. And for some individuals, a bankruptcy filing may actually improve a credit score and that the individual is better able to repay new debts after bankruptcy without the burdens of pre-existing debt. David Skillman explains what he sees in terms of how a bankruptcy filing affects an individual's credit score.
If a debtor has a low bankruptcy score, somewhere in the 500s or below, and they come in to meet with me and we're filing the bankruptcy, when I pull their consolidated credit report, it will predict that their credit score will increase generally over the next 12 months by anywhere 30 points to 130 points. Once they file the bankruptcy, those derogatory marks, the delinquencies and past dues will be replaced by a bankruptcy indicator. The system skips over those and doesn't read them as derogatory, so the score starts increasing. That's the effect I see when people come in with bad credit scores. Sometimes people come in with a good credit score. Sometimes that's because they have been paying all their bills on time and their credit score is currently very well in the 700s or 800s, or they've been kiting balances. Some people come in and they've been making the minimum payments just enough to keep their credit scores elevated, or they've been paying off one credit card on a month with a new credit card that they've just opened. So it looks like on paper they're liquid and solvent. So when people come in with good credit scores in the 700s, I would say, when they file bankruptcy, they do suffer a credit score decrease in the following year because the bankruptcy is considered derogatory at that point. All right, next I'd like to talk about how debtors obtain credit after filing for bankruptcy. And I believe there's a misconception that after you file bankruptcy, debtors will not have a credit available to them, but that is a fallacy in my experience. I find that the average debtor will receive credit card offers in the mail immediately after they file the bankruptcy, and this is because creditors realize that they've just discharged all their debt, they're more liquid now, they have more cash now because they don't have to pay all those old debts that were discharged. So now they will have money to pay new debt on credit cards. And I think credit card companies lenders want you back on the treadmill. So there is credit available in my experience.
We have heard and seen many advertisements and arguments in favor of mortgage rescue organizations and debt consolidation alternatives to bankruptcy. And some of these alternative offerings, when they are legitimate, are the right fit for certain individuals. However, our experience in the bankruptcy clerk's office is that many individuals pay these organizations only to end up in bankruptcy, with less money and more debt than before. A key difference between a bankruptcy court and mortgage rescue for debt consolidation companies, namely, is bankruptcy law is federal law that can bind a creditor with or without the creditor's consent. Also, a part of certain filing fees, the bankruptcy court is within the federal judiciary and is taxpayer funded. Tom McIntyre explains his experience with clients who have contracted with mortgage rescue or debt consolidation organizations.
Most of us would like to take the path of least resistance. So whenever you have a financial problem, a lot of times you'll contact a debt servicing counselor or a mortgage counselor in an attempt to resolve the issue. They often don't disclose a lot of the things that you need to know. For instance, if they were successful in eliminating some of my debt, would I have a taxable consequence? Well, truthfully, you're going to get a 1099-C more than likely from the lender. 1099-C might mean that you have a taxable consequence. It might not, but you're probably going to get that as a requirement by the IRS. I asked her whether or not this was going to be on my credit report. It's going to be on there, okay? Anything that you do that is related to your credit will probably be on your credit report. Finally, I had a discussion with her regarding the cost, and then I found out that the amount of money that was going to go to her company was equivalent to what it was going to cost to do a Chapter 13 bankruptcy. Now, I'm not saying that some of these companies are not legitimate, but I am saying that some of them are not legitimate. Unless you know the difference, you're just kind of stabbing in the dark. You don't really know which companies are good, which ones are going to take good care of you, or which ones are just going to take your money. Now, a lot of times these things work in this fashion. These companies will work with some of your creditors, maybe not all of them. So when you send them a monthly installment, often what they're going to do is pay one creditor at a time, to the detriment of everyone else. So when that money goes in that account, these other people are upset because they're not getting paid. Usually they don't prorate them so that everyone gets a little bit of the money at the same time. Some of them do. I mean, it's the people who come into my office who have had this experience say that they don't pay all the creditors. They start getting telephone calls from the ones that are not getting paid, and sometimes they're sued, and then attempts are taken to garnish their wages, put a judgment lien against the real estate, different attempts to collect on the debt. So my recommendation is be a wise consumer. If you're going to consider using one of these companies, research them. Find out whether or not they're legit or whether or not they've had any problems with their customers being sued. And my final recommendation is call a bankruptcy attorney. Sit down with them. Their consultations are generally free. I don't know anyone who charges a fee to just sit down with you and discuss your situation. It's going to be well worth your time and peace of mind.
As in any myth, this one is cloaked in a few truths that are amplified by an active imagination. Ryan Johnson, clerk of the Bankruptcy Court for the Northern District of West Virginia, explains how bankruptcy information is made public.
When an individual files a bankruptcy petition, they include a list of all their creditors. When the bankruptcy court receives the petition, we send a notice to every creditor on that list that the individual has filed a bankruptcy petition. Also, credit reporting agencies check bankruptcy court records to see who has filed, and will put a notation that an individual has filed bankruptcy on the credit report. Each year, however, between 700,000 and 1.5 million bankruptcy cases are filed. Unless it's a celebrity case, or somebody affirmatively checks the public record, few people may know that you filed for bankruptcy.
Michael G. Claggett, an attorney in Bridgeport, explains the difference between losing a job because of bankruptcy filing and losing a job for engaging in inappropriate conduct that violates a condition of employment.
Often I will have potential clients coming into my office and asking about whether or not they could lose their job because they filed bankruptcy. The way the law reads is this way. Employer may not terminate you solely because such debtor was in bankruptcy and was insolvent or owed money and the debt's been discharged. But the term solely means exactly what it says. If there's any conceivable reason that your employer can discharge you, it's going to happen. If the employer is inclined to discharge you, it almost has to be totally and completely contrived. The case law, including in this district, is pretty clear about that. And so the word is solely. So if a client has come to my office now, and there's been some issues he's had with the boss, especially if they're in some agency that's in the finance business and they owe them money, I will tell them that even if your employment record is spotless, you better understand that there's always that possibility that they'll try to cook up something. So in other words, on paper, it's quite clear. If you have engaged in conduct that clearly you could be fired for, and or you're engaging in clients, or maybe you have poor performance records, the bankruptcy filing is not going to save you from getting fired. But my clients don't care about that. My clients care about what's going to happen. Could I get fired? Thinking that they've done nothing wrong. And my answer to them is, I don't know who your employer is, I don't know how they act or anything else, but you do have a problem. So I see a serious problem now in this section, not protecting people who have filed bankruptcy, who have an employer that's aggressive and doesn't like them and wants to fire them because they lost money on them.
Andrew Gamble, a student intern here at the bankruptcy clerk's office, talks about how filing for bankruptcy doesn't make you a bad person.
A bankruptcy court is often referred to as a court of broken promises. Few people want to break promises. However, the reasons for breaking promises in bankruptcy court are as unique and diverse as the individual filing. Bankruptcy is not intended for those who wish to abuse the system. There are watchdogs and tests built into place to expel those cases deemed abusive. The purpose of a bankruptcy system is to provide an individual with a financial fresh start after falling on financial hard times. Sometimes these hard times are a result of our own doing. Other times they're a result of circumstances that are beyond our reasonable control, or they can result from a failed venture. In each circumstance, however, bankruptcy provides us the opportunity to learn from past mistakes, to fail forward, to begin a future liberated from pre-existing debts. Bankruptcy itself is merely a factual reflection of an individual's current financial circumstances, and is not reflective on whether an individual is morally good or bad.
This myth is only true in very few cases. It relates to a secondary myth that bankruptcy is primarily for people with a low or no income. Tom Fluharty explains common fee structures and why the statement, "I can't afford to pay a bankruptcy attorney," is so often a myth.
When people are trying to determine how to pay their attorney to file a Chapter 7 especially, bankruptcy attorneys are probably one of the best bargains coming or going. It gives you incredible relief. The number of people that come back to me to thank me for solving their financial problems is huge. It eliminates all that stress. I get rid of the financial stress. I can do that. I can do it very quickly. I can get rid of the cash flow problems. The thing you do have to do, though, is you have to pay the attorney's fees pretty much in full before the bankruptcy is filed. At one time, there were some alternative suggestions to that, but now I think pretty much all of us require that. But you can sometimes get a fee waiver or a cost waiver on the filing fee by filing the appropriate forms. Or you can ask the court to allow you to pay the filing fee in installments. I see that more often than I used to. Rather than paying the filing fee up front, you can pay that in installments over a period of time. And that way you can pay the attorney fee to the attorney and you can pay the filing fee in installments over a period of time. But I think if people just simply look at what they're paying out and do a little budgeting and work with the attorney. I charged a fee for a consultation, but I would apply it to the total fees. There may be other attorneys that will do it without a consulting fee. There is a way to arrange for the funding of the bankruptcy if you really sit down and talk to your attorney. I have people who ask me if they can file their bankruptcy on their own, and you can practice law on your own if you want to. You can practice medicine on yourself if you want to. If you have a really bad infection in your hand, you can treat it yourself. There's no law that says you can't. You can clean it out. You can buy stuff to clean it up. You can bandage it. But practicing medicine is like practicing law for yourself. If you do it wrong, you're going to suffer the consequences of doing it wrong. You're held to the standard of a lawyer pretty much when you file your own bankruptcy. And if you practice medicine on your own by not seeing a doctor, well, then you suffer those consequences when you suffer a debilitating injury.